wait for care. Maybe making them wait to be toileted. It may be withholding a favorite food or not answering their call light. That's abusive. Leaving a resident in wet or soiled clothes is an excellent example of abuse. We all get busy. But doing this as a punishment for incontinence or leaving them longer than you could get to them to assist them is considered subtle abuse. Facial expressions or gestures of disgust, perhaps you roll your eyes at a patient or roll your eyes as you walk away from them, that's subtle abuse, as is indifference or acting as though you don't care. Finally, an example that hopefully doesn't happen in your facility, but again is construed as abuse, is making fun of a resident. It's inappropriate, it's disrespectful. I share these examples with you because legally you are being held to the standard of not abusing your resident or your patient either overtly or subtly. So you need to know that these are all considered abusive. In fact, you are asked to provide reasonable care. Reasonable care can be defined as care that is given at a level that is equal to care given by another worker of comparable level of experience under similar circumstances. So it's comparing you against others in a similar situation. Failing to meet the definition of reasonable care is construed as abusive. Informed consent is one way to make sure that you're providing the care that your resident or your client expect. Informed consent is an agreement or contract between yourself and the person that you're providing care to. The client must be of sound mind, 18 years of age, without alcohol impaired or drug impaired thinking, and must be mentally competent to know what is to be done as well as the consequences of doing the action. So if you're not sure and you want to protect against something being perceived as abusive, ask for consent. An example might be bathing. Asking your resident if it's okay to bathe them. I've even heard of residents in facilities being asked by a caregiver, can I touch you? Is it okay for me to hold your hand? Can I give you a hug? Asking for informed consent from that person to make sure it's okay with them. Best way to make sure you're doing what your client wants. In terms of a client expressing their wishes to you, in addition to informed consent, there are some formal documents that are used. One of them being the last will, the other being the living will. Let me touch on both of these for you so you understand the importance that they have and the need to respect and follow them. Wills are a mean of informing other people of their wishes, both types, informing others of their wishes. The last will is a means of communicating how you want your personal affects, that shawl that meant a lot to you, those pictures in the room, whatever it might be that's personally yours, as well as financial resources. So what you want done with those things. Keep in mind that you may witness a will so long as you're following facility policy. So ask. And so long as you are confident that the person that is signing it is of sound mind and able to give, again, their informed consent. So you are able to do this per your facility's policy. So do ask. It varies amongst facilities. On the flip side, you should never help to prepare a will. That's a legal issue. And in the case that someone asks you if a request is made, what you can do is communicate this request to a supervisor and let them coordinate the request with the patient. Usually they'll contact a legal representative. So that's something that we as caregivers should never be doing. Living wills are different than last wills. Living wills is a tool to communicate what you want to have done when you can't speak for yourself. A living will indicates whether a person wants, for example, life support, wants to be tube fed, other life support devices should circumstances arise. And those, again, are ways that someone would communicate their wishes. Legal standards are in place to preserve the rights of our client as well as to prevent against abuse. Legal standards are also called laws, and their written expectations are how you are to behave as well as consequences for failing to behave in an expected way. Now, my role in this lesson is not to act as a legal counselor because by no means am I a lawyer. However, it's just to introduce you to the legal standards you will be held accountable for upholding your role as the caregiver. Negligence is the first standard or law I'd like to introduce you to. You may also have heard of the term malpractice. Negligence is the failure to give proper care. It is unintentionally doing something wrong. A few moments ago we talked about subtle abuse, and negligence is a form of subtle abuse. Not reporting information about a patient to a nurse can be considered negligence. Perhaps a patient slipped or refused to take his liquids or her liquids. Failure to report that information is negligence. It's important for others to know. Leaving wet or soiled clothes, as mentioned prior, can also be considered negligence. And again, keeping in mind that it's according to the standards of reasonable care. Assault is the second standard I'd like to talk about. Assault is the threat to do bodily harm or punish. Shaking your fist might seem like something that you do out of frustration, but shaking your fist or even a glare at a patient can be perceived as assault. If you told the resident that they better cooperate with you or else, this can also be considered assault. In short, if you say or do something that causes a patient to feel that they must comply with you or else, it can be considered assault. Now, in contrast, battery is illegal body contact, the touching of a person without their permission. Now, some people like physical contact and others prefer not to be touched and consider it an invasion of their personal space. When in doubt, ask. A safe bet is to say, "Can I? Do you mind?" So be sure to do that before you hug somebody, before you touch their hand, or touch them in any way. False imprisonment is the unlawful restricting or restraining of a person's freedom of movement. Restraining a wandering resident to a bed or locking a resident in a room are examples of false imprisonment. They are no-nos. Side rails are also commonly used restraints that could be interpreted as false imprisonment if it goes beyond the prevention of falls. So if it goes beyond that, it's your way of keeping them in the bed versus preventing them against something. False imprisonment could then be termed as such. If you are protecting someone from injury or doing something that they don't understand, or protecting them from doing something that they don't understand they're doing, you are most probably not engaging in false imprisonment. However, there is a fine line between using a restraint to protect someone and using it to disallow them their personal freedom. If you're not sure, here's the bottom line. Ask somebody that can assist you. Get advice from a supervisor whenever you are unsure. The goal is to keep them as restraint-free as possible. Invasion of privacy is failing to protect the resident's body or their personal information. It is their right to have that be theirs. Everyone has a right to keep their personal business personal, and you are expected to do what you can to protect somebody's privacy. Now, this means things like not only covering a patient when giving him or her care, but closing a door when you're toileting them, as well as avoiding gossiping with staff when you're having lunch with them. The golden rule is that what you hear or see must remain